Hello and welcome back to another episode of the Injury Law Pod. I am your host, Eric Bartlett, 28-year personal injury lawyer, and this is the podcast where we talk about all things personal injury law related. And today we have an interesting one on tap. We're unpacking a bizarre legal threat, which is the Astronomer CEO who is threatening to sue Coldplay, the band, for the Kiss Cam incident that has gone viral. And if you haven't seen this, I'm not sure where you've been living, because if you're on social media, this incident is all over, and there it has spawned a bunch of memes and humorous takes on the situation, and it's really a big mess and one that we don't see every day. And I will tell you that I took advantage of the situation and made a meme from it. We posted on our social media. And again, it's just a really weird situation. In case you're not familiar, this all started with Andy Byron, who is the CEO of the company called Astronomer. And they were at a Coldplay concert here in the last couple of weeks. And unfortunately for him and the lady he was with, they were put on that camera and they were revealed to be having an affair. Both of these people were married to other people. They were attending this concert and apparently didn't expect to be found out in public by going to this concert. But here we are. It's a moment that, again, has gone viral and has really created an interesting situation. And then again, there's that part of it. But now the fact that this CEO is threatening to sue Coldplay for exposing them really presents an interesting legal situation. And so you might ask, how is this personal injury law related? So obviously, there wasn't a personal injury per se involved in this, but the legal action that this CEO is threatening would fall under the realm of tort law. And I've talked about this before. Tort law, that is not a French dessert, but tort law is the official area of the law under which personal injury type claims exist. And essentially, if someone has, again, negligently harmed you in some way, that falls within the purview of tort law. And so this is a tort claim that he would be bringing. And in this particular instance, he would be claiming reputational damage with his investors, personal distress, and invasion of privacy. And this didn't happen in Missouri, but today I thought it would be an interesting take to break this down. What if this CEO was going to file this lawsuit in Missouri? What would that look like? Would he have a claim? What would that entail? And how would it unfold? And is this actually a case of emotional distress under Missouri law? And not only is the CEO threatening to sue Coldplay, but also the venue and the stadium broadcasters. He's going to bring everybody into his situation. And again, this presents larger questions, right? Who's really at fault here? I think most of us would probably believe that this is all of your own making. If you were arrogant enough to go out in public with your affair and you got caught, that's on you. So will this ever actually materialize or not is a question to be seen. But let's just break it down. Let's act like it's going to go forward. And let's act like for this podcast episode, it was going to happen here in Missouri. So in Missouri, he would most likely be bringing an intentional infliction of emotional distress claim. And again, he would be alleging as damages that by them putting him up on the screen with his partner was something they shouldn't have done. And when they did it, then it caused all of these problems for him. But in Missouri, in order to make that intentional infliction of emotional distress claim, he would have to show several things. Number one, he would have to show that these potential defendants, Coldplay, the venue, the stadium broadcasters, that their conduct was extreme and outrageous. And he would have to show that their conduct was intentional or reckless and that it caused severe emotional distress. So those would be the elements that he would have to meet. And so we would have to break it down, right? Was the kiss cam outrageous in and of itself? Again, from my point of view, looking at it legally, probably not by legal standards because you were at a public event. This is something that whether you're at a baseball game or a concert or whatever it may be, there has to be a reasonable expectation that you very well may end up on some video that's being displayed there at the event because they do it all the time. And so again, it's something that's a standard crowd gimmick, right? Flash people up. I think Coldplay is known to do this at their concerts. It's not the first time. And so again, was it something outrageous on their part for doing? And then the next one, was this intentional or reckless by Coldplay or the venue or the stadium broadcasters? And again, if we break it down, right, the question becomes, was there an intent on these potential defendants to harm this guy by doing this? Clearly, I don't know that there's any argument that can be made unless there's some backstory that none of us know at this point where Chris Martin of Coldplay or somebody else involved had some long-standing beef with this guy and found an opportunity to expose him, and they took advantage of that. But again, we're going way down the road into speculation here. So on its face, nothing about this has any indication of an intentional act or even a reckless act, because this is something that is just done frequently. And again, if you're looking at the person who's making the claim, which would be the CEO, you're going to have to look at whether that person should have had some reasonable expectation of being brought into the public spotlight by just being there at the concert. And then finally, to move forward under Missouri law, this emotional distress, if this was the claim being made, would have to be medically diagnosable in a lot of Missouri court interpretation. So you can't just show up at court and say, this was really wrecked me. I've been a mess ever since this because of all the fallout, things like that. You're going to have medical documentation that you have entered into some mental situation that required you to go get treatment, counseling, whatever that looks like. And then again, with those types of situations, if for any reason the CEO has prior mental health issues, has sought treatment in the past, anything like that, all of that is going to be on the table. So if Coldplay and others are defending a lawsuit like this, again, here in Missouri, they're going to have the right to take a look at what was this person's mental state before this incident ever occurred. And so if there's stuff out there in this guy's past, it's going to come out. And it might not be something this CEO really wants to relive and have hashed out in a public forum. And so going to be very interesting. And again, I think it's going to be a very hard claim to make. Now, invasion of privacy. Okay, let's talk about that under Missouri law. You know, there's a public disclosure of private facts sort of case or claim that can be made, which is basically you have to prove, if you're the one making the claim, that there was a public disclosure of a private fact and that the disclosure would be highly offensive to a reasonable person and it was not of a legitimate public concern. So the question becomes, is being shown on the kiss cam a private matter? Courts often rule that public behavior at public events is fair game. And doesn't that make sense? Again, you go out in public, what reasonable expectation do you have of privacy? You're the one, you're out there. If you're not wanting something like this exposed, then maybe you don't go out in public in a venue with, obviously, you're around thousands of people at a concert. So just the fact that you showed up there, you're already not really in a private situation. And then just by happenstance, the fact that you made it onto a video, that kind of goes with the territory. So again, in a stadium like this, there's really no expectation of privacy. You're out amongst many people. So it's going to be a very hard thing to prove that there was some exposure, public exposure of a private fact. Now, if for any reason this had involved, say, a minor, something like somebody underage, and there might have been sexual implications or humiliation with a false contact, something like that, that could have been a different situation. But these were adults and obviously had made the decision to be out there, be exposed. And so, again, very difficult hurdle to overcome. And what about defamation? For defamation to apply, you would have to have some false statement made. And here, there's simply no false statement being made about these people. Clearly, they were having an affair. I don't think there's any dispute about that at this point. So nothing false was presented to anyone out of this. And the implication or innuendo of something is not enough without false factual content. So again, the third potential claim that this CEO would have, again, under Missouri law, would be very difficult to prove. And so you don't even necessarily get to, obviously, this guy has suffered consequences because of all this. And has he been damaged because of it? Absolutely. But can he hold somebody else responsible for it? Probably not. I think at the end of the day, this all probably is going to rest solely upon his shoulders for his actions and for what he did. And he's going to have to be the one that ultimately takes responsibility. The closest things that we can talk about a little bit on this, there was a Missouri case against the Kansas City, Missouri Police Department back in the early 90s. The person there sued the Kansas City, Missouri Police Department for emotional distress after the police mistakenly arrested him and used footage on the news. And in that one, which again seems like it might have some legs to stand on, the case was dismissed. The court said that media coverage in public space was not outrageous. Here, a situation a little bit different, right? A little more egregious to us if we're thinking about privacy and being wrongfully accused and that being put out. all over various media outlets. That seems like that might actually have some legitimate standing, but the court dismissed that. And, most recently, we also have the claim of the individual that was apparently falsely accused of being involved in the shooting that occurred for the Chiefs Super Bowl parade. And that case is still underway. That gentleman is pursuing claims, basically saying that the authorities blasted him as a potential culprit in all of that, and he was not. And that's another thing that's happening right now. With this particular gentleman, again, he was briefly detained by police, but was later released and cleared of any involvement. But despite all of that, he faced social media accusations, including claims that he was an illegal alien and a shooter, which led to death threats and harassment. But again, he has filed lawsuits against individuals who spread these false accusations, including a Tennessee congressman and several Missouri state senators. Sadly, he was found dead on April 11th, 2025, with his family planning to continue the legal battle by substituting his estate to continue to pursue the claim. Really sad situation. And it's going to be interesting to see how that turns out if the legal action goes forward. This one definitely would seem to have more standing as well. There was also a 2007 case involving the Los Angeles Lakers kiss cam. And in that one, a man sued after being embarrassed by the kiss cam footage that aired on ESPN. He claimed that it impacted his job and his mental health, but the case was dismissed due to public event setting and a lack of intent to harm. This one is probably the closest to what we currently have with this CEO making the claim against Coldplay. And so, again, the fact that you're out in public and, you're doing something you don't want exposed is probably going to be a big hurdle to overcome. One other case that stands out is in 2009. It was the Girls Gone Wild lawsuit. So you may remember Girls Gone Wild was the video series that they would go out and they would get these young girls to do stupid things on camera, and they ended up turning around and selling that footage. And there was a young woman that was filmed on spring break, and they did not have her explicit consent to do. And she was actually able to recover just under $6 million from the Girls Gone Wild people because she was not informed or aware that she was being filmed for commercial use. And again, a little different situation, right? The people that were doing the videoing, they were making a profit off of this. And when somebody claims that they were filmed and this footage was used for somebody else's financial benefit, it has a little bit of a different spin. And again, here, that's different because that film was involved for commercial use and private body exposure. Again, that's what Girls Gone Wild was all about, was having girls expose themselves. And this wasn't just an innocent kiss cam situation where you're attending an event and you're randomly caught on camera doing something. So it's all very interesting. Again, I just don't think it has a very good road ahead for a lawsuit against those people, Coldplay, the venue, or the stadium broadcasters. So, how do we dial this in again to personal injury law in Missouri? There are valid emotional distress cases. It can involve workplace bullying or sexual harassment that leads to clinical mental health treatment. This could come out of a car accident or maybe a dog attack, something very traumatic, very emotionally jarring, things like that. And if post traumatic stress disorder is documented, that's absolutely a claim that can be made. Again, even in negligent actions, for example, some kind of exposure, negative exposure, say, for example, some kind of abuse in a daycare or something like that, and that leads to trauma and treatment, say, for a young survivor of something horrible. Again, very valid potential claim that they would have under Missouri law. Things like momentary embarrassment, especially if you're in public, or something where there's some kind of viral fame that happens because, again, something similar to what we're seeing in this Coldplay situation. Again, unless it causes measurable loss, you lose your job, you end up with a mental health diagnosis, you lose income because of it, whatever. Again, you're just not going to get there. So, again, to pursue emotional distress in Missouri, you're going to have to show medical records, a financial impact, or ongoing psychological harm. Just being embarrassed, even publicly, usually isn't enough. Andy Byron, the CEO, he might be aiming for the stars, but here on earth, Missouri law protects real victims of real harm, not just bruised egos. So, as always, if for some reason you find yourself injured, you really think you have a claim that measures up to Missouri law, again, we always encourage you to reach out. It's always a free call. And until then, listen, we deal with facts, not feelings. And so you just got to make sure if you go out in public and you're doing something you don't want the world to know about, then don't do it in the first place. But if you do, then be prepared for the consequences and don't expect to get compensated for it. As always, until the next episode, be safe and be well.